The Supreme Court recently heard its first case that deals with controversial protection that keeps tech companies protected from being held legally liable for content that's posted by third parties. The provision is known as Section 230 of the Communications Decency Act, and it keeps internet companies, including Google, Facebook, and other social media giants, protected from content that's posted by third parties so that they're not held responsible for what other people post on their platforms. The tech industry says that this rule is essential to keep them able to run as they do and as users have enjoyed their products. They say that if the court were to overturn the rule, it would prevent companies from being able to provide the services that users have been grown accustomed to enjoying, such as providing accurate and up-to-date information about search queries.
This case marked the first time that the Supreme Court really took on Section 230. They've been requested to do so multiple times in the past, but the justices declined to hear those cases. Now, on both of those occasions, Justice Thomas, one of the court's conservatives, wrote an accompanying statement saying that he believed that the court should take on Section 230 and that perhaps the protections had been applied too broadly. The two cases were both brought by relatives of victims of ISIS terrorist attacks. In the Google case, the court is taking on one half of the legal problem. Does Section 230 protect the tech companies from the underlying liability? In the second case, the Twitter case, the justices are weighing that underlying liability, whether big tech was liable under federal anti-terrorism laws in the first place. So if they rule that Twitter was not liable, neither of the tech companies would ever need Section 230 protections because they weren't liable in the first place. So the Supreme Court could still dodge the issue. During oral arguments in the Twitter case, a number of the justices seemed skeptical that the family could hold Twitter liable for a 2017 ISIS terrorist attack in Turkey. They seemed skeptical because they felt that if the justices were to follow the family's argument, that not only could maybe Twitter and Google be held liable, but it could have broader implications in other industries. Justice Elena Kagan raised the issue of banks and how they could be held accountable for this. Justice Clarence Thomas raised the issue of a pager company and whether a terrorist using a pager could make that pager company held liable. And Justice Brett Kavanaugh at one point asked an attorney representing the family if they were to hold Twitter liable, could they hold CNN liable for the 1997 interview they did with Osama bin Laden, in which bin Laden declared war on the United States just a few years prior to the 9/11 attacks? A number of the justices seemed skeptical that the family's theory of liability would apply to Twitter.
Section 230 has also come under fire from both sides of the aisle in Congress. Democrats say that the protection allows social media companies to take too light of a hand and leave too much disinformation and hate speech online, whereas Republicans who have accused tech companies of taking down too much content with an anti-conservative bias have said that Section 230 protects them from being able to take those actions as well. The stalemate in Congress really means that experts see the courts as deciding what's going to happen on Section 230 and as the way forward to see how this key internet law may change. The oral argument that the court was deciding this week is whether Section 230 protections should also protect platforms not only from hosting the third-party content, but also from recommending that content with their own algorithms. The tech industry has really formed a united front in terms of backing Google and arguing before the court that Section 230 provisions are essential to keeping them able to run their platforms as users expect them to. On certain issues such as antitrust reforms, different companies of varying sizes have been on different sides of issues, but companies of all sizes, including giants that are up there with Google as well as smaller social media platforms, have argued in briefs filed to the court that Section 230 really helps them provide the services that users enjoy in their platforms.
But when the court got to the case, they still now have an opportunity to resolve the case without actually reaching the Section 230 question. In a case heard the day after the Google case, Twitter came to the Supreme Court in a case that presented nearly identical legal issues. In the Google case, they believe that Section 230 protects them from underlying liability under federal anti-terrorism laws. But when the Supreme Court convened the next day, they assessed that anti-terrorism law at the center of the Google case. If the court in the second case rules for Twitter and rules that big tech was not liable under federal anti-terrorism laws, it's entirely possible that they'll send both cases back to the lower courts and not even opine on Section 230. The court previously, in declining to hear other Section 230 cases, indicated that those weren't necessarily the right cases to take up Section 230. When they took the Google case, they thought that this was the one to do it. But at oral arguments, a number of the justices seemed confused about some of the arguments, and it got into a very technical debate over YouTube's specific algorithms and recommendations, their thumbnails on video recommendations, and so it's possible that in ruling in these cases, the justices might decide that this is not the case to rule in Section 230, and that they might kick the can down the road and come back to it in a future case. If the justices do decide that tech companies can be held liable under federal anti-terrorism laws for aiding and abetting ISIS, a number of professionals and organizations in other industries have written briefs to the court warning that their ruling could have implications well beyond the tech industry. For example, a number of former State Department legal advisors penned an amicus brief contending to the justices that if they do extend liability to these companies, that in other countries, courts could use that same standard to hold Americans liable. Whether it be a country that doesn't like a humanitarian organization or a nonprofit or an NGO, these former State Department legal advisors are arguing that the ruling could have grave implications that go well beyond the tech industry.
Section 230 has essentially helped tech platforms as they see it moderate content that they see online and be able to remove content or keep it up as they see fit in line with their own policies. The issue at hand now for the courts is to decide whether this protection should keep platforms safe, as well as those decisions that they make in terms of how they're recommending content to users, as well as how they're hosting that content.